I'm Melvin Raymond, attorney at law. Welcome to Raymond Law Live. We are Happy New Year to everyone. We are already 8 days into the new year 2019. So Happy New Year to everyone. I want to give a starting shout out to Better Family Life and also to the Sims and Bailey Law Firm. Better Family Life commitment to service in the community is their mission, and you can reach them at www.betterfamilylife.org. Sims and Bailey is a Central West End law firm here in St. Louis, providing quality legal services and expert representation. You can contact them at area code 314-534-0800. I want to mention a new tool that we have on our broadcast. We're calling it What's Your Need? This is a tool to give you the opportunity to tell us what topics you want us to cover on future broadcasts. Simply email us or contact us and with your topic of choice, and we will try and get to the topic. We will get to the topic in future broadcasts. I will give you the information about contacting us at the end, later on in the broadcast. Today's topic is resonating with people all across the country, considering the Me Too movement and a recent, very controversial documentary that is on the Lifetime cable network. That documentary, of course, is Surviving R. Kelly. Many of you may have heard about that. This is a 6-part mini-series which deals with the issues of sexual abuse, physical abuse, kidnapping, and worse. And these things are detailed by various individuals claiming that they were and are survivors and victims of the entertainer R. Kelly. This relates to our broadcast today's broadcast. We are going to be dealing with the topic of domestic violence, which includes domestic abuse. If you are a victim of domestic violence or domestic abuse, then there is something you can do. That's the good news. And we're going to be discussing things that you can do if you or someone you know is a victim of domestic violence. Missouri does have a domestic violence law, or a law against domestic violence in this state, which you can go to provide some relief for domestic violence. Now, what is domestic violence? Well, domestic violence is, under the statute of Missouri, abuse or stalking by a family member or a household member. Now, the state of Missouri's Adult Abuse Act is designed to give you the opportunity, the petitioner, the opportunity to go to court and participate in the proceeding, not necessarily with an attorney. It's designed to be a little bit more informal, and you can go to the court and file a petition if you are the victim of adult abuse. Now, let's talk about, mention stalking or abuse committed by a family or household member. Now, let's talk about who are family or household members. Again, the statute covers abuse or stalking. I'm going to define abuse and stalking by a family or household member. Now, a household or family member is defined as a spouse, former spouse, any person related by blood or marriage, persons who are presently residing together or who have in the past resided together, adults who have a child in common, regardless of whether or not they are married or resided together. And also it covers, this is again, family and household members, persons of the same sex, as well as persons who have never resided together. In the instance of stalking, it would cover persons who may be strangers who not only have not ever lived together, but may not even know each other. Now, what is abuse under the law here in Missouri? Abuse includes the behavior, the following kinds of behavior, and that includes several different things. Abuse is defined as several different things or conduct. The first is assault, which is purposely or knowingly attempting or placing or attempting to place another in fear of physical harm. That's assault. Second, battery, that is purposely or knowingly causing physical harm to another with or without a deadly weapon. Another behavior that's covered, that's considered abuse, is coercion. What is coercion? Compelling another by force or threat of force to engage in conduct from which the latter has a right to abstain, or to abstain from conduct in which the person has a right to engage. Also, harassment. Harassment is engaging in a purposeful or knowing course of conduct, not just one thing, involving more than one incident that alarms or causes distress to an adult or a child. The Missouri law covers children as well and serves no legitimate purpose. Now, the course of conduct must be such as would cause a reasonable adult or child to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner or to a child. Now, what kind of things or conduct could be harassment? It could be following another person about in a public place or places. Or harassment could consist of peering in the window or lingering outside of the residence of another, but does not include, however, constitutionally protected activity. So, for instance, if someone is protesting at the mayor's house, then that is constitutionally protected free speech, and that would not be considered harassment. Very important. Also, peering into a window obviously is something that is considered harassment under the law. Another form of abuse is an act of sexual assault. What is sexual assault? That is causing or attempting to cause another to engage involuntarily in any sexual act by force, threat of force, duress, or without that person's consent. And the sixth act of abuse, as defined by the Missouri statute, is unlawful imprisonment, which is the holding, confining, detaining, or abducting another person against that person's will. Now, our statute, the Missouri statute against domestic violence, covers adults. And an adult is defined in the statute as any person 17 years of age or older, or a person who is otherwise legally emancipated. And children, as I mentioned a moment ago, are also covered by the statute. Children is defined under the statute as any person under 17 years of age. Now, if you are the victim of domestic violence or stalking, let me deal for a moment with stalking. That is also a violation of the statute. Now, stalking consists of when a person purposely engages in unwanted course of conduct that causes alarm to another person or a person who resides together in the same household with the person seeking the order of protection when it is reasonable in that person's situation to have been alarmed by the conduct. So not only do you have to have the conduct, but you have to have the effect as well. That is, it must cause alarm to the other person who resides in the same household or who is seeking the order of protection. Alarm. That's very important. What does alarm mean? Alarm simply means to cause fear of danger of physical harm. Fear or of danger of physical harm. So stalking, in other words, can take many different forms, and it's all covered by the statute. I can't think of every single thing that could be stalking, but I just mentioned just some of them. Now, what can you do if you are the victim of domestic violence, or you know someone who is the victim of domestic violence? You have to petition the court. You have to file for an order of protection. And you do that in the court in the county where you live. Now, a person who files a petition for domestic violence is called the petitioner, and the person against whom the case is filed is called the respondent. So the person that files the case, the victim, is called the petitioner, and the person against whom the case is filed is called the respondent. Very important terms here. We will also take questions and comments, and you can post those, and we will try and get to as many as we can during the course of the broadcast. Now, as far as filing the petition, you do not necessarily have to give your address to the court, especially if you're concerned about your safety. You cannot make your address public when you file the petition, but you do have to give the court your address, your current mailing address, not necessarily where you live. The court will keep that confidential if it's needed for purposes of safety. So the petition, file the petition, go to court, file the petition. It's called a verified petition. You don't need an attorney to file a petition for domestic violence. In fact, the statute is designed such that you can file the petition yourself without necessarily the assistance of an attorney. Of course, the assistance of an attorney is always helpful, but it's not required. The law wants to provide a remedy to victims of domestic violence, so it encourages people, if you don't have an attorney, to go ahead and file it on your own. The forms are available at the court, and the court clerk is required to explain the process to a person, to the filer. So the forms are available. Go to the court, go to the clerk, and they will assist you in filing it. If you're indigent and cannot afford a filing fee, then you don't have to pay any filing fee or court costs to file the petition. The court will make a determination at the end of the proceeding or at the end of the case whether or not you're indigent and cannot afford to pay the filing fee. Now, what happens after you file the petition? If you show good cause to believe that domestic violence has occurred, then the court will issue an order of protection immediately without a hearing. That's called an ex parte order of protection. So the court goes ahead, and if you convince the court that you show good cause, then you can go ahead and file the petition. The court will issue an immediate order of protection. And again, you have to show an immediate and present danger. This would constitute good cause for the court granting what we call an ex parte order of protection. It is discretionary with the court. And again, if the court issues an order of protection because of domestic violence, then the order is immediate. It takes effect immediately until there is service of process, valid service of process, and a hearing is held on the petition. So you file the petition, and if you show good cause, the court will grant immediately an order of protection pending a service of the petition on the respondent or the person who is engaged in domestic violence, and then they go to court. Now, if there is no service, there is difficulty getting service on the respondent, then that will not affect the validity or the enforceability of the order of protection. It's enforceable even if there's not been any service or notice to the respondent. So what kind of relief or protection can you get with a temporary or what we call ex parte order pending a hearing in court? One is the court can include a temporary restraining order restraining the respondent or the person, the abuser, if you will, from abusing, threatening to abuse, molesting, stalking, or disturbing the peace of the petitioner or the filer. The court can also temporarily restrain the respondent from entering the dwelling unit of the petitioner. And finally, thirdly, the court can issue a temporary order of custody of minor children where appropriate, and in those cases where you have minor children in the custody of the filer of the petition. Also, and very importantly, the court can remove an abuser from the dwelling of the filer, and it covers those instances where the dwelling unit is jointly owned, leased, or rented by both parties, and also where the dwelling unit where the petitioner lives is owned, leased, rented, or occupied by the petitioner or the filer only, and also when the dwelling unit where the petitioner lives is jointly owned, leased, or rented by the petitioner and a third party. And finally, the court can remove the abuser from a dwelling unit that's jointly occupied by the petitioner and a person other than the filer, provided that the respondent has no property interest in the property. Now, after the petition is filed, what happens next and you get service, the court has to set a hearing on the petition. So you have to go to court once the petition is filed. The hearing must be held not later than 15 days after the filing of the petition. However, a continuance can be granted by the court for a good cause. If there's a reason why the petitioner needs more time, for instance, to obtain service on the respondent, then for good cause shown, the court can continue the hearing past the 15 days after filing. Also, when you get to court, you must provide proof to the court of the allegations in the petition. That is, the allegations of abuse or stalking, and the standard of proof is by a preponderance of the evidence. Now, as I mentioned earlier, these proceedings are designed to be somewhat informal, but the court still has to hold an actual hearing, and the court has to swear witnesses and take testimony from the witnesses, and also the court will receive during the hearing documentary evidence. Now, normally when there's these hearings on petitions for domestic violence, the petitioner, of course, the victim, would testify, and sometimes there could be others who may have witnessed the abuse or the stalking. They could testify, and also if the petitioner has any documents they want to file, then the court will also hear that. So what happens if the petitioner proves the allegations of abuse or stalking to the satisfaction of the court will issue a full order of protection, a full order of protection. And that is good for at least 180 days. 180 days, that's about 6 months. And if the petitioner needs, after hearing, a renewal of the order of protection because of the circumstances, then the law does allow the petition or order of protection to be renewed for twice for at least 6 months or for up to a year. So after you get the full order of protection, you can get it renewed if necessary, and it can be renewed twice, either for 6 months or 180 days or for up to a year each time. So therefore, it could be renewed, or it could be possible that an order of protection could be in effect for up to 3 full years. So again, renewal is not automatic. You have to go back to court for the renewal, but it is possible to get the renewal if the circumstances justify it. And also, if you go back to court to renew the order of protection, then no new acts of abuse need to be alleged for the renewal. If you show that the full order of protection, it can be based on the fact of the circumstances that led to the court granting the initial petition. Again, let me remind everybody that if you have questions or comments, you can post them on our Facebook account. That's facebook.com/Raymond Law Live, and we will try and cover questions that you may have. So, once the court grants a full order of protection, what additional relief can the court give, in addition to what I just mentioned? The restraining order and so forth. In addition to those things, the court can also, and several things that the court can do if they grant a full order of protection, several things. One is if there are minor children involved, then the court may make an order of custody where there's been no prior orders of custody made or pending, and if the court finds that it's in the best interest of the child to make an order for custody. So again, if there are any existing or prior orders for custody involving the children, then the court cannot, in a domestic violence proceeding, they cannot make an order for child support. The second thing the court can do, if it does issue an order of custody, is they can establish a visitation schedule. And if the court, again, only if there's no prior visitation schedules or prior orders for visitation. Now, if the court does grant a order of custody to the petitioner, then the court shall grant to the non-custodial parent, the respondent, visitation unless there is specific finding by the court after a hearing that visitation would endanger the child's health, impair the emotional development of the child, or would otherwise conflict with the best interest of the child. Now, the court does not have to issue a visitation schedule. The court could find that there should be no visitation which can be arranged that would sufficiently protect the custodial parent from abuse. So the main goal and the main purpose of the domestic abuse or domestic violence statute is to protect the custodial parent from abuse. Also, in a domestic violence proceeding, the court can also award child support in addition to custody and visitation. And believe it or not, in a domestic violence proceeding, the court can also award maintenance. In my experience, I have not seen where a court has actually ordered maintenance that's normally taken care of in a proceeding to dissolve a marriage. But under the domestic violence statute in the state of Missouri, the court does have that power to award maintenance. The court can also order the respondent to pay the petitioner's rent, pay the rent, or to pay a fee for reasonable housing and services that may have been provided to the petitioner by, for instance, a domestic violence shelter. Also, the court in a domestic violence proceeding can order the respondent to participate in a court-approved counseling program designed to help those who engage in domestic violence to stop the violent behavior. Finally, in a domestic violence proceeding, the court can order the respondent to pay court costs and other reasonable costs of the filing party and the filing party's attorney fees. So those are some of the things, some of the remedies that the court can provide. We will, again, if there are any questions, we'll take questions. We're going to be winding up on this topic. So I want to give a final shout out to Better Family Life. You can reach them at www.betterfamilylife.org. Now, Better Family Life, they make constant efforts to be a force of good in our community. And besides their website, you can contact them at area code 314-367-3440. And I want to give a closing shout out to the Sims and Bailey Law Firm, offering quality legal services and expert representation in the bi-state area. Let me remind you, when you fight, you should know your rights. Also, I want to thank all of you who watched the broadcast today live and those who will be watching the broadcast later for your participation and your interaction. I appreciate that. And we will see you on the next broadcast. Remember, when you fight, you should know your rights. Thank you.